Before getting into more of the evidence, let's talk about where this all started. This crime ultimately stems from my divorce from my second husband, St. Louis County Attorney Rick Voytas. The full timeline of that case is available on my website. Under the evidence section, there is a link titled Case 1 Chronology. At the beginning of that case, the parties were permitted to file under our initials only. My former attorney, Susan Jacobson, informed the court that I had a domestic abuser who continued violating court orders intended to prevent his harassment of me. Because of that history, the parties requested that the case be filed under our initials for privacy. That domestic abuser was my first husband, Victor Ojeda, the father of my two sons. I divorced him in 2016. Mr. Ojeda lost legal and physical custody of our sons shortly after our divorce. He was later found guilty of domestic violence based on ongoing post-separation abuse and violations of court orders intended to prevent his harassment of me. You can review the full history of that case in the court records published on my website using the link titled Case 2 Chronology. Those circumstances were discussed with Judge Joseph Green when my divorce from my second husband began in the summer of 2021. That background is important because it meant Judge Green understood exactly what vulnerabilities existed in my sons' lives and mine, vulnerabilities that later became central to the crime that unfolded during my divorce from attorney Rick Voytas. During a hearing in October 2021, Judge Green raised the file in my divorce from Mr. Voytas to what is known as a Level 5 security designation within the Missouri court system. Cases filed under Level 5 security in Missouri's court system are known to be uniquely problematic because of the issues they pose to people's access to their own files. In fact, one Missouri news publication did a story about cases filed under that exact security level just this past January. These cases not only vanish from Missouri's public court database, but this security level can also severely limit a person's ability to monitor their own case file while the case is active. When a case is filed under Level 5 security, you're not notified when documents are filed. You're not notified when hearings are scheduled. You can't call the courthouse to ask what's happened in the case or if something new's been entered in the record. Without access to the active record, the filings, hearings, and orders, it becomes impossible to fully participate in the legal process in real time. Even when a case qualifies for increased security, a litigant can't be denied sufficient access to their own case file so they can participate in proceedings. Security designations don't supersede due process rights. Yet that's exactly what happened. I was denied sufficient access to my own active case file. Multiple attorneys were aware of the issue. Administrative judges were aware of the issue. The court's domestic relations department was made aware of it. And I formally reported it to the U.S. Attorney's Office for the Eastern District of Missouri. I met with an assistant U.S. attorney from that office. I explained that I didn't have access to the active case file or docket, and the issue was persisting, even though I notified court administration and met with attorneys who confirmed the issue existed. And that when I went to the records department at the courthouse, it took multiple trips to even get a copy of a transcript of what the file looked like at any given point in time. I got a certified transcript of the file in the fall of 2022 and showed them that what was in the file at that time did not reflect what had happened in the case, and that it could be confirmed by reviewing hearing transcripts, and that Judge Green was doing things like denying his division was in receipt of certain filings during hearings. But then in the transcript of the file, it showed they were received. But no one would know that those pleadings were treated as if they didn't exist at the time they were relevant. They'd have to review audio and transcripts of hearings, which no one does. Judge Green was recording that settlement conferences took place that did not, and he even filed a copy of a consent judgment that was unsigned by the parties that he knew I did not agree to. But then at a later date, he pretended I did, so he could claim that my contempt of that non-existent consent judgment was the basis for my sons and I to be evicted from our home and a sale to proceed without my signatures on documents. Countless people knew Judge Green was committing fraud on the court, But it was clear that this culture of corruption's nothing new. No one was going to confront a crime that involved so many powerful people within St. Louis County's judiciary. Instead, there was an effort by St. Louis County administrative judges to conceal the fact that I had even reported this issue. When I raised the issue on record during hearings with Judge Green, he didn't correct it. Instead, he responded with threats, at times even suggesting I could be detained by court security when I was trying to raise the issue. But by formally reporting what was happening to officials responsible for overseeing the court system, I made sure there could be no question later that this obstruction was intentional. And that's where the mechanism I described earlier becomes important. If someone intends to fabricate a court record, even to the point of claiming that a consent judgment exists when no such document exists, controlling access to the case file becomes essential. Because if the parties involved could freely access the record as it was being created, the fraud would be much easier to detect and report.